Good morning. My name is Gero Verheyen, and I'm the Data Privacy Officer for MIGA. Welcome to World Bank Group Data Privacy Day 2021 and the IFC MIGA Roundtable on Data Privacy in the Private Sector. Data Privacy Day is an annual event hosted in Washington, D.C. by the Legal Vice Presidency of the World Bank. Due to COVID-19, this year's event is fully virtual. During this discussion, we'll be exploring the challenges for companies which current and new data privacy policies springing up across the globe are presenting. I'm delighted to welcome and introduce our distinguished panel of experts. Fealey is Global Chief Privacy Officer at Citi. She has a deep knowledge of privacy programs, having previously established and built up privacy programs at Prudential and American Express. Eduardo Ustaran is the global co-chair of the privacy and cybersecurity practice with the international law firm Hogan Lovells and is recognized as one of the world's leading privacy and data protection lawyers and thought leaders. Cline is the privacy leader for PricewaterhouseCoopers in the United States and is an expert in law, technology, and business. He specializes in privacy legislation and information security standards. Shamali de Silva is Chief Counsel for Operations and Policy at MIGA. She oversees and advises on policy-related issues such as data privacy. And Ceri Lawley is the Chief Compliance Officer at the IFC and leads the Business Risk and Compliance Department. She oversees data privacy, compliance standards, and advising units in business and corporate risk. A reminder to our audience that we will be taking questions throughout the session. Please use the box in front of you to share your questions and comments, and time permitting, we'll respond to questions which have been submitted via the chat. Let's start with a question to all of our panelists. Please take 2 minutes to respond to what has been the top challenge your organization has faced in complying with privacy regulations across the globe. And let's start with you on that.
Thank you, Gero. As I said to you earlier, that this is a challenging question. I have a number of different top challenges for us. So, my first one was thinking about the what you had said. The laws that are coming out. They're just for a multinational organization and a global economy to deal with all the different types of privacy laws that are coming out across the globe has been very challenging. But if I had to actually pin it down, because then I thought, the growth of data is another big challenge, and just with the growth is more personal data, and with that more sensitive personal data, adding to the difficulties to classification, to securing it, to keeping it confidential, to even knowing that you have it. But actually, if I had to pinpoint one of the top challenge, it's about deletion. So, for companies that are older and have legacy systems, it's tough to actually implement deletion requirements, and those requirements are coming fast and furious at us.
Thank you, Anne. Let's turn to Eduardo.
Hello, and thank you. So if there is a challenge that I have seen organizations facing in 2020 beyond, of course, the pandemic, it is connected to what I would call data globalization, or the ability for data to truly flow globally. The reality is that sharing data globally has never been perhaps more important. Today, the only thing that can truly travel is data. And it's so important because it's necessary among other reasons to fight a global pandemic. So at the same time, we've seen greater restrictions than ever before from courts, from regulators, from a number of organizations that are seeking ways to localize the data. And therefore, the challenge is to overcome those barriers in a way that respects privacy, respects data protection, and the security of the data, but at the same time allows data to flow freely throughout the world in order to achieve its purposes.
Thank you, Eduardo. Jay, how about you?
When I think about our multinational clients, Gero, I think dealing with the rapid increase in the overall risk exposure of privacy has been the biggest challenge. If you think back in just the last 2 years, I'd say the stakes for privacy have doubled and the complexity has tripled. And just thinking across a few different parameters, privacy enforcement is up over 100%, not only in the United States, but in Europe and even China now. So across every region, however you count it, by the number of enforcement actions, the dollars. Also, half a dozen countries with more than double the population of Europe are now adopting revenue-based fine regimes for data privacy, with most of the new growth happening in Asia. And also the share of global population covered by the rights to access and delete and data breach notification will tip past 50% for the first time in history in 2021, with, again, much of this growth happening in the developing world. And now, finally, investors are moving their money based on your company's ESG, environmental, social, and governance scores. And privacy is a component of that. So we've got across the board multi-stakeholders in an organization are affected by privacy now.
Thank you, Jay. Let me turn to Shamali.
Thank you, Gero. Good morning, everyone. Happy Privacy Day. So it's fair to say that we have had a number of challenges getting to this point. And virtually on the eve of the World Bank Group privacy policy going into implementation, good progress has been made in the governance framework area, some technology solutions, and the outreach and awareness. But that said, there's still a lot to be done. And data privacy is a relatively new area that is still evolving. And the World Bank Group will also be following the trends globally to see what would make sense and what is appropriate for the bank to adopt as well. Now, that said, in my view, the biggest challenge is managing the enormous volume of data that is received by the bank group, both structured and unstructured. And in a number of instances, this data belongs to third parties with whom the bank group does not even have a contractual relationship or legal arrangements. So on the one hand, data and information is needed for the bank to carry out its unique mandate as a development institution. And unique because when we talk about the group, there are 5 separate institutions that make up this group. And so in order to deliver on the unique mandate or distinct mandate of each of these institutions, data and information is needed, whether it is for due diligence, underwriting, risk analysis, or research. So in my view, the challenge is really balancing the need for data and information with the enormous volume that is received, and I should say also collected, and then managing this process going forward. Thank you, Gero.
Thank you, Shamali. And let me finally turn to Ceri.
Thank you, Gero. So for me, I think the biggest challenge is it's pretty easy for me to pinpoint. For me, it is that the World Bank Group, to pick up what Shamali said, it comprises 5 international organizations set up under international treaty, owned by nearly all the countries of the world, and not being a corporation in the conventional sense. So, what does that all mean? We're not subject to regulatory oversight of any national regulator anywhere. So the big challenge for us in the first instance is to figure out what standards we should actually be complying with. And it sounds like quite a luxury, but actually it's very hard. And it's very hard because our stakeholders expect a lot from us. Our regulated partners expect a lot from us. And the world is looking at us. So we need to set the bar high. And the other flip side of that challenge is how that fits with our mandate. Because at the same time, we have the mandate of really trying to address extreme poverty in the world, to boost shared prosperity, a very challenging mandate that takes us into the most fragile and conflict-affected countries. So while we want to set the bar high, in some of those countries, data privacy is not the top priority. So the challenge is sort of juggling that mission and mandate, wanting to set the bar high. I'll stop there.
Thank you, Ceri. So we're going to move to a question for Anne. Anne, you've been involved in privacy issues in the financial sector for over a decade with different institutions. Privacy policies during this time have evolved, and more recently, national and regional privacy regulations have given the issue a much higher level of prominence. Citi is one of the leading global investment and financial service institutions. In your opening remark, you mentioned deletion as perhaps the biggest privacy-related challenge you have faced. How is this being addressed at Citi?
Yeah, thanks. And hearing from everyone else, it sounds like such a minor thing. But we're actually addressing all of the challenges I mentioned in a similar way. And if I just want to back up a little bit. So we've had a lot of these privacy law changes, and I think that's really been driven. I think everyone on the panel would agree with me. It's driven by the European General Data Protection Regulation that was finalized in 2016. It was effective in 2018. So we've had 3 years of it being in effect. And in those 5 intervening years, we've seen just a massive amount of privacy legislation, both countries that already have legislation amending their existing to mimic the GDPR, and new legislation. And I think we've seen that globally. And Jay actually touched upon this, and I heard someone else from Omar Tene from the IAPP privacy organization mentioned that with the India proposed legislation, the China proposed legislation, and then with the legislation that passed in California earlier this year, you have a great deal of the world covered by privacy, which is phenomenal in the past 5 years. So with all that in mind, we look at the GDPR as that standard because the laws are mimicking that regulation. So to address the challenges, especially the challenges that we've talked about, the 2 key areas we're looking at would be technology and people. So on the technology side, it's leveraging the technology solutions, and I think Shamali mentioned this, leveraging solutions that allow us to do certain things that we have to do. So allowing us to respond to data requests from our customers and our employees. If you have technology that does that in a seamless way, you are able to do it, so that you're satisfying the customer as well as complying with the laws that require you to do it within a certain amount of time. Technology that allows you to transfer personal data from across borders from one country to another. And Eduardo mentioned this, when you have data localization laws that blocks that transfer. But if you have technology that allows you to look at that, where there are data localization laws, you can block the transfer and not allow it to be transferred. But where you don't, you can actually do it in a compliant way. Technology that allows privacy impact assessments, these risk assessments that you do from a personal data perspective, it's done more easily and in a compliant way, and you actually have the evidence to show that you're doing it. And technology that allows you to do personal data inventories and keep them updated in real time. So we really are looking at data, and the last point, data deletion. So if you have technology helping you find your data and being able to delete it when retention schedules end, when you no longer need it, then you've got data deletion, pretty much covered. The second point on the area is our people. So when I joined Citi, we looked at staffing up the central team to manage the program better and improve the program management, but also to make sure that our line one, our business teams had the right, privacy attention. So it wasn't just a job that they were doing, in addition to their other job, it was a job that they were doing full time. And then training those employees, so training people that worked in privacy, allowing them to get certified through the again, that organization, the privacy organization, the IPP, has certification classes and certification tests that you can take. So, and we are working with the IPP on a multi-year plan to get more of our privacy professionals trained and certified in privacy, but also training our employee base generally, because privacy, like data security, data privacy, is everyone's responsibility at the company. And across the firm, we want people aware of that. So making sure that we've got those awareness sessions, like this one that you've organized, awareness sessions across the company.
Thank you, Anne. If I can ask a follow-up question. You've now built 2 privacy programs from the ground up at Prudential and American Express. And right now, a lot of companies are in the process of doing that themselves at various stages. What key pieces of advice would you be able to offer them as they undertake this endeavor?
Well, I definitely wish them luck, but I guess I would go back to those areas that I'm focusing on and Citi's focusing on. Look at technology solutions and look at it to help you future-proof your program, because the better technology and the better that technology can be advanced for, like, future scenarios or future data, the better off you'll be. And also people, make sure that you've got the right attention to staffing up your program, and this is going to depend on the company. So a company that is, business facing may not have a lot of personal data, may need a smaller team than a company that is consumer facing. So it really depends on the company, but to have the right people, and the right training of those people, I think those would be the 2 areas I'd recommend people to focus on.
Great, thanks very much. Let me turn to Eduardo now. Eduardo, Hogan Lovells is one of the leading international law firms. It has a global presence and with clients no doubt challenged by the new privacy regulations emerging around the world. With GDPR moving into its 3rd years and regulations being enacted in many other jurisdictions, what's proving to be the greatest area of legal risk for your clients in practice, and what are they doing to address this risk?
The area perhaps of greatest legal risk is linked to something I refer to in my introductory words, which is to do with data globalization. Because in the context of the GDPR, right now, the greatest risk is to fall foul of the restrictions that apply to transfers of personal data from the European Union to other countries around the world. In particular, in connection with the jurisprudence that was developed last year by the European Court of Justice, which essentially said that when an organization in Europe, or a global organization that is exporting data out of the European Union to another country, that organization must avoid the potential for indiscriminate access to that data by government agencies, by public authorities, which are part of the power of the state. And that creates a real conflict, because most organizations that operate internationally will face this dilemma sometimes of complying with these access requests from governments all over the world, which may well be to do with the security or indeed the health of the population or the financial well-being of that country. So at one level, those are strong legal requirements that apply. And then at the same time, the GDPR requires the protection of the data and the privacy of that information. And therefore, there is a potential for conflict there. And the question is, how do we resolve this conflict? And that is because that's the risk. And what we have seen and what we've been working on with a number of, with many organizations throughout the world, is to try to find ways, practical ways, to minimize that risk from materializing in the first place. And that in practice involves a number of steps. First of all, it's really important to understand the potential for those risks. And that means it's important for organizations to understand which data is going where, under what conditions. The nature of the information itself may attract different degrees of risk. Different countries provide their governments, or the laws of different countries provide their governments with different levels of power and access to that information. And it's important to understand that that's a very difficult thing to do at a global scale, but at the very least, there has to be a sense of understanding of what powers a particular country has and a particular government has in order to have access to that information, and for what reasons and what controls that government is subject to. And it is through that understanding of the risk that then you can assess it. And when you assess the risk, then you can apply the right level of protection. And therefore, the next step is to ensure that at least there is a baseline level of protection that follows the data. The European Court of Justice, when it pronounced its ruling in this respect, it did not say data must never flow out of Europe. What it says is the protection of European data protection, so the GDPR, must follow the data. And the way you do that at a baseline level is to ensure that the mechanisms that are readily available to protect that data, some legal mechanisms, are in place. For example, the European Commission is in the process of adopting the next version of what we call the standard contractual clauses, which is a legal mechanism that imposes obligations on the exporters of data and the importers of data to ensure that these types of indiscriminate access to data are prevented. And then once you have applied that global level of baseline protection, then it may still be the case that additional safeguards need to be deployed. And right now, it is very important to understand that regulators in Europe and elsewhere are expecting these additional safeguards to be implemented when data is facing this risk, in additional measures that may take the form of extra contractual provisions or organizational measures that are directly aimed at controlling and managing this access to data requests by government. And then it is through those mechanisms, and including technological mechanisms, that you can try to minimize that risk. And my final point is that, as difficult as it is, what I always say is we should focus on what we can do, not on how difficult this is or what we cannot do, but what we can do. And through these mechanisms that I've just explained, there's a lot that can be done to address this risk.
Thank you, Eduardo. Very insightful and helpful. Jay, you're with PricewaterhouseCoopers, and you advise public and private sector clients across the globe as a thought leader on data privacy issues. In an article recently published in your weekly newsletter, you said that privacy laws emerging on every continent are changing the way companies do business in the post-pandemic economy. You go on to talk about a tripolar privacy world. Could you tell us a little bit more about this and what exactly you mean by a tripolar privacy world? And what changes do you see your clients making, and how do they fit into this tripolar world? Thank you.
Sure, Gero, thanks for the question. I think when we look at 2021, it's shaping up to usher in the biggest wave of privacy and data governance legislation in a decade. And this wave is coming in the context of, I would say, a geopolitical struggle over data sovereignty. If data is the future of prosperity, you know, the future of the economy, then it's the future of power. And so it reminds me of a quote that's attributed to Sir Francis Bacon, that knowledge is power. Well, I think now data is power. And so territories are shaping their new laws and regulations. When we look at the database that we maintain, I think we're counting over 2,500 laws and regulations that mention personal data or have a requirement in it, that they are coalescing around three models, the Chinese, European, and USA model, which each have distinct aspects and are not converging anytime soon. So with the unique aspect of China's, for example, and Russia, and to some extent India has the same part of it in their law, is government access to data through mandated localization. So that's one model. A unique aspect of Europe's is something that Eduardo had mentioned, is data localization mandated through data transfer restrictions. So the rights follow the data, otherwise the data has to stay home. And with the Schrems decision that Eduardo was alluding to, it's calling into question, how do you do cloud computing in this regard when governments may have access to that data? Unique aspect of the USA model is a risk-based multi-stakeholder enforcement model. The United States is the mother of privacy enforcement at all levels, multiple federal agencies, state attorneys general, and then a very robust class action culture. And so these three different models, developing countries, when they're bringing on their new laws, they want access to these three large markets. And so as they're shaping their laws, they're innovating. They're bringing in some of each of these different models. And we see, for example, in Singapore, you've got a really nice innovation about a regulatory sandbox for big data to help innovate big data, because they see, like other countries see, data is the future. And how can we make this happen and not stifle it? So there's a competition, like there used to be a competition for foreign direct investment, which is ongoing. There's a competition for data investment. So going forward, I think multinationals, you'd ask, what are we doing about this? What are multinationals doing? We have to do a lot better job at pseudonymization techniques. Eduardo was mentioning looking at how data flows and reducing our surface to government access to data. Well, pseudonymization is one way to do that. It's one way to get across some of these data transfer restrictions and localization restrictions. But also, I think to make this happen, it's really hard to use pseudonymized data in a lot of business processes. So it's going to require some re-engineering. You know, back in the 90s, there was a wave of business process re-engineering. I think we're going to see that again. And true privacy by design in all technology implementations.
Thank you, Jay. If I can ask one follow-up question to that. On your in your newsletter, also you make reference to a road trip per se around the world, speaking with your data privacy principles, which you've been able to do since the beginning of the pandemic. What have been some of the key takeaways from different regions? You've mentioned China and India, but from some of the other regions that you've discussed with your principals.
Well, yeah, so I did this road trip for a couple of reasons. Well, first, I'm jealous of Ann and her global team, and wanted to check in with my team as well, and also just to travel, because we've all been shut down. Wanted to imagine going to far-flung places, and I was surprised at the bills. Some of them are in the makes that we've already talked about, but some are not. But in the developing world, I would say it was the big eye-opening part for me, because we focus so much on the big players, the big countries, and what they're doing. But this wave has really washed to every corner of the world. In Africa is well covered by privacy legislation or bills right now. Middle East, and so it really is a global phenomenon. And when I look at how we measure, let's say, consumer views of privacy, that's changing too. China and India consumers historically have been more accepting of privacy impacting technologies than, let's say, Western consumers. That's changing in the younger generation. All over the world are expecting privacy rights. So there is some convergence of attitudes happening across the world.
Gero, I think your microphone is muted.
Sorry. Let me turn to Ceri and Shamali now. In your opening remarks, you talked about all of the data that the institutions of the World Bank Group collect to support projects and with which we are fulfilling our mandate. And our personal data privacy policy becomes operational on February 1. What are some of your thoughts on what you've just heard from Anne, Eduardo, and Jay? Let me start with Shamali.
Thank you, Gero, and fascinating listening to Anne, Eduardo, and Jay on some of these issues. Given it's also a relatively new area that we are, trying to get comfortable with. So I'll start with one of the questions I had for Anne. I completely agree with you, Anne. Technology solutions is probably going to be key and very important to how we manage the data and how we process it, archive it. And I think you earlier had talked about deletion. What part of the deletion is even legal? Because are we supposed to archive this data and actually give it back to the people who own it? So also on the technology, it's a balancing act, right? Because there's a cost and benefit implications and resources as well. And the technology keeps, of course, moving, and we are constantly playing catch up. So I think that's something also to keep in mind. What is good today may not actually be 6 months down the road. And so we'll have to be nimble and swift in how we do that. And I guess for institutions like the World Bank, we'll be following the trend. But I'm also thinking about some of the countries that, Jay, you talked about, India, or even poorer countries. How do they really, find the resources to keep up with the requirements, right? So that's one question. And I don't know, Anne, if you had any thoughts on this. And also really, Eduardo, you really freaked me out when you talked about the legal risk and the conflict. This is real for the bank group as well. And we constantly do talk about that because, we have a broad range of products and instruments that we deploy within the bank group. And I think, Ceri, you talked about the stakeholder group that we engage with. And so these products and instruments go from loans to the sovereign, sub-sovereign, state-owned enterprises to the private sector. And then MIGA does the political risk insurance. And so our client base is quite different from the World Bank, IBRD's client base. And then we have ICSID, on the other hand, who does the arbitral forum as a secretariat. So, the risk that you talked about, Eduardo, manifests in very different ways for the bank group, right? And I was wondering if you had any thoughts, on how a multilateral like the bank would manage this risk going forward. Thank you.
Anne, do you want to start with a response?
Yeah, unfortunately, I don't have the answers. They're tough questions. I think even at a company level, you always struggle with, that cost benefit analysis when you look at technology, because things do change very quickly. On the deletion side, you're absolutely correct. We are mandated by other laws to keep data for a certain length of time. So, there is always that balancing act, because if you delete data that you were meant to keep, not only are you at risk for violating other laws, but it's also, if it's personal data that belongs to, our consumers, it's a risk of a data breach and an incident that is reportable, because that data needs to be available to them. So it is a balancing act. Many companies, it depends on, again, the type of company and the comfort level in developing technology versus purchasing technology. But many companies and many smaller companies are purchasing technology because then those third parties actually keep the technology updated. And so it's not on, the company itself. But again, and I think you raised it, there's third-party risks related to that, so you do have to balance it. And I think it was Jay that mentioned it, some of the regimes, a lot of the regimes we're seeing are implementing fines, and, whether or not that is a revenue stream for the countries is debatable. We've seen in some cases in Europe some of the fines that go to fund the privacy regulator. So I know in other places in Europe and other places around the world that's not the case, but that's also, I think, being considered.
Thank you. And Eduardo, I give you the opportunity to reassure Shamali that all is actually well.
Let's see how I can do reassurance. I think there are two key components to managing the risk, which are optimism and pragmatism. And by that, I mean, being optimistic about managing the risk is to believe that there are solutions to these challenges, and to believe that there is some common ground that can be found, and to believe that it is possible to find that way forward. And I think something really important to understand is that quite often data protection is presented as the enemy of doing business, is an impediment, when the opposite is true. The reality is that data protection does not get in the way of doing business. It just is something that, again, needs to be managed and needs to be understood, and ultimately exists for a reason. The European approach to data protection, and it was very interesting to hear Jay's approach in the different cultures, but the European approach is very much based on the fact that the protection of our personal information is a fundamental right that people have, as we all have, irrespective of where we live. And that makes you think that it's not in itself an impediment, it's a way to ensure that you can do what you're trying to achieve, and the operations and the very valuable activities that, for example, as a bank you may undertake, but in a way that is still respectful of people's privacy and people's rights. And you need to bear that in mind. So it's a mindset issue. So that's a little bit blue sky thinking. But the other element is the pragmatism, to which I refer to. And as a lawyer, my job is to find pragmatic and viable solutions. And that's why I was referring, for example, before to contractual mechanisms. So agreements between the parties to say, look, if you have a government agency in your jurisdiction requesting access for data, let's understand that, and let's assess together how we deal with that. In many cases, that access will be entirely justifiable, and it will be compatible with European data protection, or indeed data protection around the world. In some aspects, it may need to be qualified, and it may even need to be challenged. And that doesn't mean that the business cannot carry on, but it may need to be addressed in a way that looks at whether that country and that jurisdiction really needs to have access to that data. So it's about finding the solution and having the mindset of sort of a can-do mindset. And I think if you do have that, then it's how you manage the risk. And that's what I tell my clients every day to try to reassure them.
Thank you, Eduardo. Jay, did you want to come in on this as well?
Well, I think when we think about the pandemic and even the business case that privacy leaders make for privacy going forward, but looking back on the results of the last year, I think definitely legal risk has and will always be a part of the business case. But people also, after this year of reflection, want to work for companies that they believe in. They want to do well and do good. And when we think about privacy, I think there's a business case in the ESG agenda, environmental, social, and governance agenda, that we look at data and are we using it to address disparities in our employee and consumer base through our products and services? Disparities, whether it be racial or gender or socioeconomic based. This is the exciting part, I think, of the globalization of data that we've been talking about today. We can use data to do good. And there are different stakeholders that are interested in supporting privacy programs with that mission.
Thank you, Jay. Let me turn to Ceri and get your thoughts and questions based on the initial responses to the questions.
Well, I wanted to pick a comment that Shamali made right at the beginning when she was describing some of our World Bank group challenges. She mentioned, first of all, that we receive a lot of data that we haven't asked for. And we also receive a lot of data from third parties that we have no contractual or other relationship with. It makes it very challenging to know how to manage that corpus of information. And I sometimes think it is much larger than the corpus of data that we have relating to our clients and our staff and our vendors. And that prompts me to raise an issue which hasn't yet been touched on, which is how one goes about handling requests for data. So data subject access requests, DSARs. So when a person comes forward and says, what data do you hold about me? What does one do? It's impossible to find this data with any degree of thoroughness. One can be optimistic and pragmatic, to pick up Eduardo's sort of language and approach. That's what we're trying to do. But I'm very interested. I would direct the question to everybody, but particularly to Anne. I would ask, first of all, how many such requests are you getting and how are you sort of resourcing for it? And also, how are you responding to it? And how are you searching, since you mentioned, Anne, legacy systems, how are you searching in legacy systems for this data to be responsive and to provide something meaningful to the requester?
Yeah, they're all good questions, and it is difficult, and it is very difficult for the size of the firm to be able to manage those requests. If we think back, I think in Mexico we've had those kind of requests in place for quite a while. They're called ARCO rights, but it was the same sort of data protection rights that people had in Mexico. So how Citi has handled it to date has been country by country, typically manual processes that the business puts in place. And then, my team oversees that process and makes sure that it's working appropriately. And that's probably due to the fact that we hadn't gotten a lot of requests. I think that's, because we're a big bank. I think a lot of the requests were more so concerned in going to technology-based companies where people, had put a lot of information out on Facebook and wanted to know from, Facebook or Twitter or, the other type social media companies about information about their data. Another area I think that has received a lot of requests are marketers, so marketing companies that do, especially internet marketing. But they face the same challenges that you're talking about because, for us, those requests come in typically from customers. And for our customers, we can find that that data, and we can respond to them. And that's really, globally going to be customer relations. So it's not necessarily we do it because we have to. We do it because it's part of our customer experience. We want to make sure that that customer, has a good experience with us. I think for people that may come in who are not customers, that's where we would struggle the same as you, because if we had gotten that data from a third party, if it's like a beneficiary or something, that wouldn't come up necessarily in the customer databases. So that does become a challenge. And we've had to create solutions to look for that data as well. And in certain cases, respond to it because the laws require it. That's one reason we're looking at, improving our technology. So when the California law came out, we were able to work with our consumer business in the United States and develop technology that would help us globally. And when we built that, we built it, as if it could be leveraged globally. Now, there may be instances of it in each country just to, ensure that we've got language and translation requirements, built in. But we built that in mind, to how do we improve our customer experience, and how do we, make sure that we can properly respond in a timely way, and in a customer satisfaction type way.
So can I just follow up? I mean, I was interested in your remark, Anne, that the data has to be collected manually. I was also taken with your comment that there haven't been so many requests. So going back to your point about staffing up, have you had to staff up significantly to handle
I think
requests?
that's one. Yeah, it's a great question, because that's one area you do that balance. So we will always look at the requests that come in and balance it against the money we would spend on the technology, or the people that would manage that process. But the one thing that I would point out is there could be anything that might be out of your control and at any point in time, which would increase the number of requests, and you have to be ready to respond to that. So, it could be, a data breach at a third party that, causes consumers and people to be more aware of their data, and they might reach out to, different banks or different, institutions that they have business with and ask, well, what about my data? Have I been affected by this? Especially if it's a third party breach that, it's a vendor or a supplier of your company, so that's always the balance, and this is why I believe that the technology solution really has to be built and leveraged for, and I agree with what Jay and Eduardo said, this is an asset for us. This is a customer relationship. So we should be, spending our time paying attention to that, because that's going to, embed the customer with us and trust us to do what's right.
Excellent. What about you, Jay and Eduardo? Do you have any thoughts on this issue?
Well, I do. I think sometimes we breathe a sigh of relief when there aren't many data requests coming in, because that's less hassle, less expense, and maybe it seems like there are fewer problems that people might be motivated to find out what's happening with their data. But I would say if we reverse the lens and think about consumer engagement, and think from the chief marketing officer's perspective, something what Anne was referring to is engagement of the end consumer. Right now, if we measure, when we're brought in to measure the Net Promoter Score of consumer engagement, it actually goes down when people have to engage with the data request process. It's kind of clunky in a lot of places. It's hidden. It's hard to find. It really wasn't designed with consumer experience in mind. So we want that to be a better experience, but we want people to be really engaged with their data. Because when they're engaged with their data, first they're offering higher quality data. They're interacting more often in general, and they're a better consumer. They're the kind of consumer that we want. So a sign of more requests is actually what we want. And I guess for all of us privacy leaders, the more requests, the more volume helps us make the business case for automated technologies for both data discovery and the the ticketing, the processing of those rights.
If I can briefly add to that, from my perspective, obviously, as a European data protection lawyer, I can't help thinking that we're talking of a very important right. It's a fundamental right, the right to access our own information. It's not an absolute right, but it's an important right. But of course, like everything, no matter how important it is, to get it right comes down to having the right process. And I think Anne and Jay have very explained from their position of experience how they advise to have that process. And we do the same. And it's important to know where to look and to understand what the structure of your data is within the organization. It's important to know how to respond, what deadlines you're facing, what exceptions apply, because as I said, it's not an absolute right, and there may be some exceptions that apply. And then ultimately, and picking up on what Jay was saying, responding in a helpful way, in a way that perhaps you rely on templates that you've created in order to meet those requirements. So it's important to picking up on what we were saying, deploy the right processes, but bearing in mind that we're talking about a very important right.
Thank you, Eduardo. I want to pick up on a point you made in response to Shamali, I think. You said that data privacy is not evil. It's not getting in the way of being able to do business. But I think when you consider that, organizations, they have a privacy department and a compliance requirement that is institutional, but the actual business units, their main focus is on developing business. And so getting buy-in from those units to agree with what you've said can often be challenging. Is what has been the experience, and I know, Jay, at PwC, you advise a lot of companies on data privacy and putting their programs together. What's your experience been with this?
Well, I think the important change is how many stakeholders are now involved in privacy. And with accelerated digitalization, the CIO is now involved and has specific outcomes they want from the privacy program. The chief data officer is deploying AI in data analytics in new ways. They have very distinct needs. And I see in some cases, the AI data governance and privacy organizations are coming now under the same leader. Chief Marketing Officer still has customer 360 engagements and goals, especially now with most of us at home. How do we understand the customer? Product teams are accelerating the deployment of IoT and really need privacy at the table. And supply chain has been disrupted, especially in the industrial products and services sector. And so procurement and supply chain need help in rethinking global data architectures. So we're seeing privacy, if traditionally privacy was funded by the General Counsel's office, but now to be an effective privacy leader, you've got to be clued into all of these different stakeholders, getting their requirements and designing your program to support them. That takes a much bigger team, even for the smallest organizations that are not even Fortune 500 organizations, to be effective. I think that's the biggest change for me.
If I can follow up with Anne, in your experience of developing privacy programs, has getting buy-in from the business units been a challenge for you, or is that less of an issue at financial institutions?
Yeah, I mean, again, it's a balancing test, but I don't think I've ever really faced a challenge like that. I think when you present it in a way that I think both Eduardo and Jay pointed out, that it's an asset for the company, and it not simply just a requirement by compliance, a requirement by legal. So flip the message and say, as an asset, this will make a difference to your customers. If you invest now, you will gain more followership, you will gain more customers, and that really has resonated with the business. And I think more and more we're seeing that. So more business engagement.
Thank you. I think we have a couple of questions from our audience. Let me start with one question. Some organizations' data have leaked from recent hacking. What are some of the measures that you are considering to prevent data leaks, or how are you advising on this? If I can present that to our panelists. Anne, do you want to start with that, or?
Yeah, and I think Eduardo might have more to say on this, but yeah, we work closely with our data security team and office, because you really can't have data privacy without data security. So ensuring you've got the right controls, so you've classified the data appropriately and you've got the right controls against that. And it's a moving target. The hackers, those bad actors will always be out there. So it's keeping up on what they're doing to make sure that you've got your controls and your controls are working.
Yeah, if I can add to that, I think cybersecurity is obviously a very important element of data protection, and in Europe is part of it. But like many things, it's about first preparing for it. Assume that it's going to happen. Don't just treat it as an if. It's more treated as a when, and therefore run exercises and try to put yourself in a position as if it was happening already. And secondly, develop a way that allows you to respond very quickly. One of the greatest challenges of cybersecurity in recent times is that there is greater pressure, regulatory pressure, to notify data breaches and incidents. And you need to decide very, very, very quickly how, when, and to whom you're going to notify. And to do that in a panic, when you're still trying to figure out what's happening and what data has been compromised, and you may be facing a ransomware request and you don't know if it's genuine or not, and you are in this panicky situation, unless you know already what you need to do, it's going to be very, very difficult to make the right decisions. So like with everything else, it's about planning, rehearsing, and being ready so that when the crisis happens, you know how to deal with it.
And being nimble, because sometimes when it happens, those plans, you've got to change them quickly.
Jay, did you want to add any thoughts on this?
I think it's the same challenge we've had for the last 30 years, and the same solution is you have to know what your data is. You have to know the threats to that data, and you have to continually assess it and keep up with the changing threat landscape as the threat actors change their tactics to that data. It's an ongoing, annual, sometimes daily process of assess and adapt.
Great. Thank you. We have about 1 minute remaining in this session, so I wanted to take a moment to share some key takeaways that I've heard from our panelists today. Very interesting discussion. And if you look at it, data privacy can appear as a very daunting issue when considering all of the legal challenges across jurisdictions, understanding what has to be in place in order to be able to move data across jurisdictions from one country to another, understanding what the laws are if you're running afoul of them. Data privacy also, from an organizational point of view, presents some interesting challenges in terms of not only the technology solutions that need to be in place and the manpower, but a fundamental question is really understanding what data do you actually have, and where is it in your systems? And I know for the World Bank Group, given the amount of data that we collect, it comes in all forms, and a very large part of it is unstructured data that our staff are receiving in the course of doing surveys and receiving surveys from third parties in support of our projects. And so finding that when a request comes in becomes a huge challenge. I want to take an opportunity on behalf of MIGA and the Data Privacy Office at the IFC to thank Anne, Shamali, Ceri, Eduardo, and Jay for joining us this morning. I hope everybody who has viewed this event via the live stream has enjoyed it. And if you have further questions, please post them in the chat, and we will post answers on the IFC and MIGA websites shortly. Thank you very much.